So Delhi High Court recently came out with a judgment in the case Karan Antil versus High Court of Delhi and others. Karan Antil versus High Court of Delhi and others. This case pertains to the recruitment in the Delhi Higher Judicial Services. The petitioner in this case challenged the candidature of one of the person on the ground that, sir, to be appointed as in superior judiciary, in Delhi Higher Judiciary, as per Article 233 of the Constitution and as per the notification of the Delhi High Court, the person must be is an advocate with 7 years of experience on the date of filing of the form, and it should be the continuous period of advocacy. So he alleged that a person, a candidate, I think he was on serial number 5, that this candidate, he pursued his master's LLM from London during that period, and since he was not in India and was pursuing his LLM, there was no question that he was practicing in court. So as such, his candidature should be taken off the record. So the High Court observed and decided in this case. High Court observed the rules of the Bar Council of India. Bar Council of India के High Court ने rules पढ़े. Bar Council of India rules contained in section 7, chapter 2, as well as the Delhi High Court rules, that is the notification, apart from that Article 233. High Court said two things. High Court said, as per Article 233 or the Delhi High Court notification, the requirement for being appointed or being eligible to apply for the post of Delhi Higher Judicial Services is 7 years as advocate. It is nowhere written that it is 7 years of practicing advocate. Court said that there are different ways. It is not required that every person go to the court and institute cases. There are persons who just give legal advice, right? There are persons who help in some other way. There is no requirement that the person must be a practicing advocate. What is the requirement is the person must be enrolled as an advocate. So first condition, this person was enrolled as an advocate. There is no requirement that he should have so many wakalatnamas. Though in certain states, this is what I am telling you, certain states like Haryana and others, they ask you for a minimum return and this. But this judgment is very good. Actually, this judgment has followed another judgment which was passed by the Andhra Pradesh High Court on the similar ground. And the Andhra Pradesh High Court also dismissed that challenge, which the Delhi High Court also did in the present case. Further, going ahead, after perusing the Bar Council of India rules, the High Court said, Bar Council prohibits a person who is an advocate to run any business, to be a director of a company. He may be a director, but he should not be the main director. He can be a sleeping partner. He can be another partner. Let's say a person has a family business and some family member dies. Then obviously the person has to take care of the business. So his role has to be seen. So Bar Council of India restricts certain things. It nowhere restricts an advocate from pursuing higher education, be it LLM, be it PhD. It nowhere stops it. The person remains valid, the person remains as advocate, enrolled as an advocate, unless the person himself surrenders. And this notification of Bar Council dates back to 2009. 2009 में उन्होंने ये अमेंडमेंट करी और 2009 के बाद यदि आज की डेट में आपको मैं सिर्फ ये कहना चाह रहा हूं कि आप लोग तैयारी कर रहे हैं, इमीडिएटली पास आउट होने के बाद आप एनरोल कीजिए. जिस दिन आप एनरोल करेंगे आपका एक्सपीरियंस एज ए एडवोकेट काउंट होगा. एंड समटाइम्स like things like corona may come and there is a delay in your selection, then you may also get eligible for various other posts, including the public prosecutors APP in Delhi, which is conducted by the UPSC, and maybe for higher judiciary. So this judgment, though of a high court, is a landmark. You know, the court has gone through plethora of judgments on various aspects and come up with a very wise decision in this, because this will rather encourage a law graduate, an advocate, to go for higher studies, because there were many cases where a lawyer wants to go for higher studies, but because he feels that he may lose his experience for that time, because at the same time he or she wants to appear in certain exam. So that is a very welcome judgment. So I thought that I should discuss it with you. It will be very helpful for those among you who are pursuing LLM or want to pursue LLM.